Mr. Great to have you here today. I suppose you have a bit of an opening statement and you have some guests with you I'd like you to introduce. And so please, if you'd like to do that, Keon. We'll go to Mr. Budd as our first question.
We have here Matthew Lynch and Isabel Mondu. They are two officials from the Privy Council office, and they will be helping with any technical matters with which the committee may need assistance. As for an opening statement, I'd rather maximize time and accountability for questioning, so I have no opener.
Super. Thank you, Minister. That's always helpful for the committee to give them more time to talk.
You touched on two issues. One is vouching and one is the use of the voter information card as a form of ID. Let me address the latter first and the former second. The voter information card draws its information from the National Register of Electors, on which 1/6 names have false information. It follows that 1/6 cards then are false. That allows for people to vote either more than once or in places where they do not live. We saw an example of this in the Quebec television show Infoman, where two Montrealers received two voter information cards each. They each voted twice. And they called it the Elections Canada 2-for-1 special. Canadians voted for many years without using the voter information card as a form of ID. It's been piloted in recent elections by Elections Canada. Due to the inaccuracy in the lists on which the card is based, we are ending the use of that card as ID. The card will still be available to inform electors of where they vote. They just won't be able to use it as ID. There will continue to be 39 pieces of acceptable identification that Canadians can use to identify their person and their address. On to vouching. I've regularly cited the statistic that in 4 ridings audited by the Neufeld review, there were a 25% rate of irregularities when vouching was used. If you look nationally, the same report found that there were irregularities in 42% of cases where vouching was used. 120,000 vouching incidents occurred in the last election, and there were 50,000 irregularities. It's been suggested more recently that these were small matters. Failure to cross T's or dot I's. That, in fact, is absolutely false. And if you'll permit me, Chair, I'll quote directly from Elections Canada's own compliance review. Errors that involve the failure to properly administer these procedures are serious. The courts refer to such serious errors as irregularities, which can result in votes being declared invalid. It goes on. Too frequently, the errors are so serious that the courts would judge them to be irregularities that violate the legal provision that establish an elector's entitlement to vote. On page 10, it says, nonetheless, the case found that elections officers made many serious errors in their duties on Election Day in the 2011 Etobicoke Centre election, and the Supreme Court made it clear that such errors in other circumstances could contribute to a court overturning an election. And if I could quote right from the Supreme Court, in recognizing that mistakes are inevitable, the court does not condone any relaxation of training or procedures. The CEO has an obligation to ensure, as far as reasonably possible, that procedures are followed. Failure to live up to this mandate would shake the public's confidence in the election system as a whole and render it vulnerable to abuse and manipulation. Those are very serious words from our Supreme Court directed at the CEO of Elections Canada in the aftermath of mass irregularities. We are going to end these irregularities by ending the use of vouching and voter identification cards to voter information cards to ID voters.
My question to you is, and it's a very simple one, why are you refusing to consider hearings outside the safety of the Ottawa bubble And why are you denying Canadians an opportunity to have a say about their election process in the communities where they live?
Well, I'm not. The committee is the master of its own destiny. It can hear any witness that it wants. I would encourage you to put forward a full list that is representative of the entire country as you consider the viewpoints of Canadians from across the land before this committee. And I will leave it to you as the assembled members of the committee to determine where you hold those hearings. That being said, you did make some comments about the consultations with the CEO. You weren't at the meeting, but it was not just a, "Hi, how are you?" I listened for about an hour to the CEO's suggestions until, in fact, he ran out of things to say. I told him if he thought of anything else, he should give me a call and that we could talk further. I also read his many testimonies before this committee and reports, which are publicly available, and took them into consideration in adding 38 of his recommendations to the substance of the Fair Elections Act. That is, I think, a very comprehensive consultation. And furthermore, we'll look forward to hearing input from the many witnesses that you'll bring before you.
Well, Minister, first of all, if I can, Chair, to correct my own record, it was the Transport Committee, not the Trade Committee, just to be accurate. I want to say, well, let me ask the Minister. I agree it's the committee's purview to decide whether we should go outside Ottawa. Let me ask you the question directly then. In your opinion, would it be a more democratic and healthier process for Canadians if we took these committee hearings outside of Ottawa? Your opinion?
That really is a matter for the committee to decide.
Oh, so you're dodging, Minister, and I got to tell you, this is just consistent with what we've seen. I have the floor. This is consistent with what we've seen so far. We are definitely concerned that a serial cheating government is trying to pre-cheat the next election before we even get to it. And all we're seeking at this stage is an opportunity for Canadians to have their say. The Minister can be as cute as he wants, saying that it's the purview of this committee, but we all know who's calling the shots. And if this Minister and the Prime Minister said there will be public hearings outside Ottawa, there would be. They're shutting this down, and it's not a process that we're willing to accept, Chair. Let me just last say, we want to get off the process issue. This is not where we want to fight. These are serious issues. We want to get out into the communities and talk about the bill, but we need a fair process. Ramming electoral changes through the House and then through this committee is un-Canadian and unacceptable.
There's a minute left. Did you want to give it to Mr. Scott? Okay, Mr. Scott, 1 minute.
Thank you, Mr. Chairman. Thank you, Minister, for being here. I was wondering if I could go straight to an issue that's caused some concern, which is the current Section 18 of the Act, which you've replaced or want to replace with a new version that's very tight and excludes, in its own language, excludes any other public education activities other than what's listed. You've suggested some openness, and my question is, why would you not be open to retaining the current Section 18, which has all the public education functions that has led to things like Democracy Day and the Student Vote Program, and then layer in on top of it your specific informational duties that you want the Chief Electoral Officer to undertake? What's wrong with having the two side by side?
Clearly, the public advertising and outreach campaigns of Elections Canada have not worked. Since they came into effect, voter turnout has actually plummeted. And the problem is even more persistent amongst the groups that the campaigns purport to help. I did some research into some of the practical obstacles to voting that exist in Canada and found that many of them are very practical. 60% of non-voters say that everyday issues got in the way of their casting a ballot. Those include everything from being out of town on elections day to being too busy to cast a ballot. There are two problems that can easily be solved with advance voting. The problem is that half of young people are not aware that they can vote in advance of elections day. It's a number that rises to 3/4 when you talk about Aboriginal youth. And as a result, I think we need to advertise those basics of voting, where, when, and what ID to bring and what special tools are available to help the disabled cast a ballot.
Thank you, Minister. I gave some extra time there to the answer to your question. So we'll.
It's not a question of ordering the referee off the ice. You certainly took his whistle from him, which made him ineffective, or never really gave him a whistle in the first place. And second of all, now he is off the ice. So don't you think this is more isolation than anything else?
Not at all. In fact, the Fair Elections Act will continue to permit the Commissioner to ask information from Elections Canada or any of its officials. None of those powers are removed by the Fair Elections Act, nor does the new legislation prevent Elections Canada from providing information to the Commissioner. They can have a free line of communication one to the other. Well, the independence we provide is to allow the Commissioner
Minister,
to control
if I may,
just finish answering. It was a very long question. The answer is that the Commissioner will have the ability to manage his own staff, run his own investigations, and he can do so without fear of being fired because he'll have a fixed term for the first
You've
time.
made him neutered. Without a tool.
Nothing could be further from the truth. In fact, the Fair Elections Act gives the watchdog sharper teeth, a longer reach, and a freer hand. What does that mean? Sharper teeth means tougher penalties for existing offences. Longer reach means that he'll have dozens of new offences to impose. And on that particular point...
Can I address those three things?
No, because I'm not finished. The reality is that the Commissioner will have a new offence that he can impose, which is anybody who obstructs his investigations or lies to his investigators will be committing offence under the Act, one that can be prosecuted. And that will allow him to cut through the obstruction that so worries you. But you raise the issue of police powers to compel. Police do not have that power. Police who are investigating the most heinous violent crimes cannot force someone to speak.
But I just illustrated a point where they did.
The Commissioner has all of the same powers of investigation that a police officer would have. The Commissioner can...
So why is he wrong when he says he wants more?
The Commissioner...
Why is he wrong? Specifically, why is he wrong? I've only got a few minutes left, Minister. Yeah. Why is he so wrong
the power
for asking what he wants?
The power that the Commissioner has to seek information is already present under the existing Act.
Then what did he ask?
He can ask a judge for a warrant to obtain evidence, and after charges are laid, he can ask...
What about before charges are laid?
The testimony can be compelled in the court of law. That's the way it works when investigators in police investigations carry out their work for much more serious crimes than you're discussing here. And the reality is that he has these tools, and we're giving him more under the Fair Elections Act.
And don't you think that an investigator with Elections Canada...
That's not what you're asking for. That's not what you're asking for.
But that's what they're asking for.
You've changed the subject.
No, I have not.
You were on
No, I have not, because this is what they... In order for them to get to the bottom of the scandal for robocalls, I'm asking for what is in Section 11 of the Competition Act.
Which is not wiretapping.
Which is exactly... But it's the power to compel for evidence, the ability to investigate effectively. Wiretapping is about police doing their jobs.
So are you talking about wiretapping or the power to compel?
About them doing their jobs.
You're going to decide what you're asking for, because a minute ago you were asking for the power to compel testimony. Now you're talking about. Now you're asking for the power to wiretap. So I don't know exactly what your policy proposal is.
I'm asking for the ability to investigate before charges are laid, which is what you're not providing in this legislation.
That's completely false. The Commissioner has the power to investigate before charges are laid. That's what he does for a living.
To compel evidence, to apply to a judge. If the judge does not feel...
Thank you, Mr. Sims.
If I could conclude, he can compel evidence by getting a search warrant right now.
Thank you.
I don't know if you're aware of this, but there were student polling stations for students and back in the last election, and they used their voter ID card to vote. Now you're getting rid of that possibility, so young people will no longer be able to use this measure, which was a pilot project back in 2011. Are you aware of the impact, the negative impact that this will have on youth voter turnout in the next election? I'd like to thank the honourable member for her question, but I do not agree that this will reduce voter turnout, particularly with respect to young people. Why? Well, as she said, young people, students, voted without using this voter ID card for many, many years without any problems. Secondly, there are 39 other ways to identify yourself, including the student card. I have a list here that I could share with you. And finally, the Elections Canada had to inform young people about the type of information, the ID that they needed in order to vote. And I think that this will help out. They will be aware of what documents they need. I'm aware of all of that, Minister, but when you repeat that there are 39 pieces of ID that people can use, could you tell us specifically how many ID cards can be used on their own? Well, the 39 pieces, how many? But how many pieces can be used on their own? It depends. Driver's licenses, health cards, provincial ID cards or territorial ID cards, that's it? Those are already available. That is one option. But I have to correct you. I have to correct myself. That's not all, because there's another option as well. This second option is that you can use 39 other pieces of ID, and I have the list here before me. When I was a student in Rimouski, I got my driver's license late. So when the minister says that fewer than 2% of Canadians are without a driver's ID, I wonder about that. There are a lot of people who don't have an ID. It can really vary from one place to the next. And when you're talking about young people, obviously they're the ones who have the least number of, least likely to have a driver's license. And when you say that you can use a student card to vote, well, that's not realistic for a lot of young people who don't have any proof of residence, so they won't be able to use their ID, a student ID, in order to vote. But at any rate, I have other questions that I'd like to tackle. I would like to add, that's not the only document that a student is acceptable. The student could also use correspondence from a school, university, or college. There are 8 other ways that the student can identify themselves. But that's not going to improve voter turnout. But it's not by enabling students to use an unsafe way of voting that's going to do it either.
The need for the approval of the Treasury Board is something that I'm very concerned about in terms of inserting the government between the Chief Electoral Officer and his ability to carry out studies.
I don't think you're referring to Section 20. You're referring to Section 5094.
No, I asked, please, would you, Section 20 of the Act, of the new Act, is the question.
Well, the new Act doesn't have sections. It's because it's not an Act yet. It has clauses.
Would you answer the question, please? You know what I'm referring to. Treasury Board approval for hiring specialists, such as Neufeld.
Yes, you're referring to Clause 20. I think.
Clause 20 in the new Act.
Yes.
Section 20 in the new Act.
Right. So, Section 20, you're relating to there's something called the deputy head of any organization. Mm-hmm. Right now, the deputy head, for the purposes of staffing and contracting, is the CEO of Elections Canada. Mm-hmm. We're making the commissioner independent of the CEO of Elections Canada. Let me finish. And that will make the commissioner his own deputy head for the purposes of the Public Service Employment Act. However, for the purposes of the Financial Administration Act, the deputy head will be the Director of Public Prosecutions. And as a result, he will play the functional role that is currently played by the CEO of Elections Canada with regards to contracting.
My question was about the Chief Electoral Officer's ability to hire specialists only with Treasury Board approval. I asked Mr. Lynch to be prepared for a second question, which you're dealing with, and you're not actually answering it. The first question is Treasury Board approval to hire the Neufelds, the Institute for Research and Public Policy, all of those. Is that correct, that you now need the President of the Treasury Board's approval for the Chief Electoral Officer, not the Commissioner?
I'll let the official comment on that.
The Neufeld report recommended the expanding of the use of voter identification cards.
I am aware of the recommendation. I'm also aware of the data, and I appreciate the excellent work that Mr. Neufeld did in providing that data. The reality is that Elections Canada has acknowledged that 1 in 6 people on the National Register of Electors have false information associated with their names, and that false information then flows onto the voter information card. We cannot have voter information cards that have errors 1 in 6 times used to identify voters at the polls. It is too susceptible to abuse, and that's why we're removing that form of ID.
Just go back to clear up the confusion with Mr. Lynch. Could you give me an answer on Section 509.6? The new, what would be in the new Act is 509.6. And the simple question is, with a certificate of the DPP, Director of Public Prosecutions, can the Commissioner hire investigators and other specialists on a temporary basis directly from the Consolidated Revenue Fund? Because it's not mentioned, that the provision Section 509.4 is not specifically mentioned in 509.6, and it's just a clarification. I'd love the answer to be yes, and I'm wondering if it is.
Yes, if you refer to 509.6b, refers to any expenses incurred by, on behalf of, or in relation to the Commissioner under this part.
It's included in that, in your interpretation. Okay, that's all I need. That's very good. For the Minister, Section 376 of the new Act is the clause dealing with exempting fundraising calls to pre-existing donors who've given $20 or more. I'd love to ask you what the $20 or more is about, but what I really am concerned about, apart from the advantage it gives to parties that have the extra money to be running full ramp, these kind of voting operations have established voter donor bases, that's obvious to everybody. My question is, the wording of this provision, in your view, does it allow a party to make calls where they simply add in an ask, where they say, oh, by the way, could you please donate? And at the same time, the purpose of the call is getting out the vote or asking to volunteer or persuading somebody to vote?
No, that is not a concern. And it is based, I've heard some other public commentary that is also false on this point. And I'll have to break it down, though, Mr. Chair, with your permission. First of all, the number of donors a party has is a tiny fraction of the number of supporters it has. So if a party was just to call identify its donors to ask them to vote, they would be doing a get out the vote enterprise of a very, very tiny fraction of their overall support base. Furthermore, they'd be calling the people that they least need to call. Donors are the least likely to miss voting day. They're obviously civically engaged enough to give of their own money. They're going to give of their own time to vote. But I could just finish, if I could finish on this point.
You're both going to finish because you're over time. So.
If I could just finish on this point. To think otherwise is to conflate two completely distinct and different functions of a campaign, voter turnout versus fundraising. I would also add that the NDP had a very similar rule in its leadership race, and I can quote from it right here.
We heard that in the House. You're over time.
This is listen, he asked the question. I want to give the answer. It says here that expenses for fundraising are not subject.
Come on.
Well, if I could finish, I know the NDP doesn't want to hear its own rules, but those rules state that any fundraising.
Thank you.
If I could finish, I've been interrupted 4 times just trying to read one sentence.
But
a silly argument, but he's
interrupting the chair when he's trying to say thank you, Minister, for coming today, and thank you for giving us all the information you can.
Thank you very much.
Have, and thank the whole committee for its politeness and how well it went today. We'll suspend just for a minute while the Minister gets a chance to leave, and we'll come right back in.